He's a Fulton County chaplain. He's a black cowboy. He's all the things. And one of the greatest takeaways is having a great client, right? A great client is definitely the difference maker between winning and losing. And then unbreakable testimony, because it was the truth from filing the lawsuit to deposition to trial testimony. So having my father as my client wasn't the easiest. Let me just be clear on that. He didn't listen always. He didn't prepare adequately. But what I started to realize when I was kind of getting anxious towards the beginning of trial or gearing up for it is that he really didn't have to remember a whole lot because he told the truth from the very beginning. There were no lies told. And so there was really nothing he really needed to study or go over because everything that he needed to talk about, he had already spoke about in the deposition. And even the things that he did, like go fishing, ride a horse one time, he said it in deposition and he also said he paid for it. So there was no lying there. And I'll get to why that's very important as we continue. Injury summary and key medical facts. So the key details, let's start with the facts of the case. So it was Super Bowl Sunday. He was preparing for Super Bowl Sunday. If anybody knows what Super Bowl Sunday is in the Christian community, that is Easter Sunday, Resurrection Sunday. So it was the day before, and he and a good friend of his who was a chef, they went to Restaurant Depot to go purchase some items for the big Resurrection Sunday festivity. So while they were there, they shopped all around the store, made it to the very last aisle, and my dad saw a 36 pack of Pepsi. He was like, oh, this is bigger than the normal because it's kind of like a warehouse for restaurants. He picked it up, he turned around, and he ended up in this dangerous, slippery mix of broken glass and liquid while holding the 36 pack of Pepsi. He ends up landing on one knee, and then he has the pack of Pepsi, of course, on the floor at this point. And that did prevent him from having all kinds of scars and scrapes because he didn't, have any cuts or anything, thank God. There were no warning signs, there were no caution signs, but there were several employees around that ended up coming to his rescue. So there were two employees that ended up coming over to my dad's rescue. Now, mind you, of course, the good friend of his who was the chef was also right there and witnessed it all as well. So one of the employees began to tell my father how frustrated she was because the employee who was responsible for that aisle had left to go to lunch, but he was aware of the slippery mix because he had pulled a crate from up above and it dropped to the ground. And that's how all of those boxes had begun to spill out Torini syrup. Now, before we get to the next slide, it'll show all of the key facts and evidence. It'll show all the evidence, the physical evidence that I'll have. But let's just quickly talk about over the span of the 4 years, his medical treatment. So he, of course, had herniated discs. He had some injections. The injuries were shoulder, neck, back, knee pain. And then one of the biggest things that he did towards the end was mental trauma therapy, which I will be glad to provide any and everyone with this information because it is a game changer. He also treated for about 6 to 7 months. And then what I called a 3 year pause during the trial, not that he stopped treatment, it was a pause. Because as a man of great faith, because I said he's a clergyman, he's also a bishop, he owns his own church. He wanted his body to heal himself. And when his body failed him, he ended up going back what a normal person would do when they're believing in God for their healing and restoration. It didn't happen for him. So he had to go back to treatment, and that's why the 3 year pause is there. He didn't have any broken bones or limbs, no hospitalizations, and no surgeries. Now let's get into the evidence.
I have a
So,
question before you move on.
sure.
So when you said he treated for 6 to 7 months, is that immediately after the fall he started treatment
That is
and
correct.
then paused for 3 years? Okay, so there wasn't a delay from the fall initially, right?
No, there was no delay from the fall initially. There was the 6 to 7 months of treatment, and then there was the pause for 3 years, and then he started back 3 years later.
Gotcha. Thank you.
No problem. So here is the key evidence that was presented in the trial. Yes, I did have the 36 pack of Pepsi. I held it up during my opening statement, and I made sure that they knew that it weighed 31.4 pounds and it was equivalent to a 2 to 3 year old toddler or a 30-pound dumbbell. I also had the Torini bottle. And I was using it, basically showing the consistency of it because it is kind of like, um, the nature of it, the consistency of it is kind of like real liquidy. So you could see that it could cause someone to slip and fall. It wasn't like syrupy. The consistency is a little bit different from other Torini bottles that I've seen, which was quite interesting. This is a picture of the actual incident, the origin spill, and then where the actual incident took place. So you have the arrow pointing to the incident spill, and you see the box of Tarini there. So he kicked the box over to the side, and then he left the broken bottle of glass, the broken glass bottle of Tarini right here. So we originally had one spill, but then it ended up being another spill because he put the box of the Tarini bottles over to the side, which is where my father slipped. So you see the Pepsi, that's where the incident took place. So he's coming up the aisle from where you see the Pepsi, the Dr. Pepper. He's coming from the back of that aisle, so he can't see the broken bottle yet. So you can't say open and obvious because you can't see that. And then they, of course, were trying to use open and obvious because ahead of him was the spill, but you have this 6 feet long cart that they're pushing, which I've never seen anything like that. And then mind you, they had made it to the end of the store. So they had ribs, utensils, all that already piled up on this 6 foot long cart. And then to the right, you had my father writing names down of the people he spoke to and the guy who was responsible for leaving the spill on the aisle, which was also really good of him. And then the deli manager, his name is on there. He reported to the scene, he made the incident report, and he took pictures. All right, this is the video that they gave us. I want you guys to take a look at that. All right, I'll pause it. There's really nothing to see here, right? So I ended up playing this video during trial and basically was like, what did we just watch? Now, mind you, he told me during his deposition that he saw the incident and he sent it up to upper management. So where is that video? This video shows sometime after the fall happens, and it is also taken from a far distant camera when they had over 64 cameras in the store. And right there where the incident took place, there were about 5 or 6 because there is a manager's office that is literally on the other side of that wall. So there was definitely footage that could have gotten closer and captured the actual incident. We did mail a certified notice to preserve 2 days after the incident, which was great for us. And the camera system magically went down 2 days later, and they put in a service ticket for it. So in their notice to produce, their documents that they produced during discovery had that inside of it. And I was like, this is golden, because how funny is it that the cameras go down 2 days after? And then even in the note, the ticket said, we can't see all the cameras how we could see it last week. So we did file a motion for spoliation. The judge denied it. We did a motion for reconsideration. The judge denied it. Me and my co-counsel were kind of going back and forth because he felt like, well, why show it? They should show it. And I said, no, we should show it because I think that would make the jury even more upset. Even though we didn't get the motion for spoliation, I think they're smart enough to grab hold of what we're looking at here. And they definitely did. I was glad that we introduced it with the deli manager when I put him on the stand. All right, pre-trial highlights. This is the juicy stuff that people really, really want to know. So liability was never accepted. Our original demand was for $73,623.20. And the insurance first offer was $6,500. In 2021, the bills totaled to $23,623.20. 3 years later, it progressed to medical bills totaling $96,632.80. We did have a mediation where we asked for $250,000. Their offer was $10,000. In between mediation 1 and 2, we did send an offer of judgment for $1 million. And of course, at mediation 2, we were standing on that $1 million, and they came back with an offer of $100,000. Let that all sink in.
Oh, we're clocking it.
I was putting this together and I was so tickled because some of these numbers I forgot and I was like, wow. All right. So my trial theme was admission, but no accountability. Because when I deposed the deli manager, he admitted that he saw the incident, but no one had ever taken accountability. There was no liability that was accepted. So basically, this was essentially my theme. This is the team on defense side. Of course, my team, our expert witnesses, is a full breakdown. So Atkins Daughtery was my co-counsel. I actually worked for his firm before launching my own. He taught me so much. So it was only right, and it was a full circle moment to have him as co-counsel. Judge Jay Roth was the Fulton County State judge who presided over the case. And then you had four lawyers on the defense side. Now, Janice Laborde was the lawyer that I actually dealt with the entire time, along with, who was not pictured here because she was not with the firm by the time we made it to trial, my law school, my very first roommate in law school. Her name was Chanel Patrick. She was actually one of the initial attorneys along with Janice Laborde when the case first started, which I thought was hilarious, but she left the firm along the way. So then Brent came in, and then Nikki Bradley, and then Jay Barber was brought in 2 weeks before trial, and he was the one who led the entire trial. Janice spoke one time. Brent did a deposition. He did not sit at the table with them. He came in and out throughout the days we were there, which was 3 days. And Nikki Bradley, she basically just presented all the evidence on the screen for the lawyers. That was pretty much her involvement. Now, we did have two expert witnesses. We had Dr. Polydor, who was excellent on the stand and deposition. Highly recommend him. He's an orthopedist. He just opened his own practice. He used to be, I think, I forget where he was before, but it's a very popular place, but he's now in business for himself. William Plumley was our economist. He was amazing. He is a very respectable economist. I mean, there was nothing that they could get by him. He's just solid and he's very even keel. His temperament is excellent for the stand and for any jury. And we had 7 lay witnesses. They had 0 lay witnesses and 1 expert witness, which was the economist. And they essentially tried to use Facebook because they had an investigator. They were trying to use, the judge did not allow them in after our argument based on her, but they did use Facebook as their evidence the entire trial. Really, that was all that they had and used. The makeup of the jury were 5 Black men, 5 white men, 1 Ethiopian woman, and then the alternative was a Black woman. Partner strategy. So I was responsible for opening statement. I did the direct examination of all 7 lay witnesses. I did 2 cross examinations of the defense witnesses, which was the 30B6 deponent, as well as the deli manager. Me and my team were responsible for the trial binder. We were also responsible for trial strategy and theme. And then, okay, I already had that at the bottom. So yeah, we did the depositions. I did the depositions, but I also examined them during trial too. Atkins Daughtery was responsible for the closing arguments. He examined both P and D economists. He did Dr. Polydor's deposition. He also handled motions in limine, voir dire, and jury charges. He has done countless trials, so it was only right for him to do all of the pre-work before we get to trial because, of course, this is his thing. Voir dire is also one of his greatest strengths. He kills voir dire, so it was only right to have him over that. And I also learned a lot by watching him. There was no bifurcation. Judge Roth basically said that this case will be treated like pre-SB 68. Atkins came in, I wanted to note this too, he came in at the top of the year. So I've had this case, of course, for 4 years. The incident took place April 3rd, 2021. So he came in the top of 2025. I think we started having conversations towards the end of 24. And so he kind of parachuted in and kind of helped cleaning up house and giving tips and handling the portions that you see on the right side. Defense tactics. As I mentioned before, Facebook was the primary evidence. They had over 20 plus posts. They all were basically around the same thing, that he basically had his agility. He could move around. There were videos showing him walking because he's also, what I didn't mention, my apologies, he has owned his own construction business for over 35 years. So they were showing him walking some of the properties, but they never showed him doing any lifting. So our thing was, we never said that he couldn't walk. We never said that he couldn't, do any talking or recording. Like, he was never bedridden. That was never said. So there was nothing that was incriminating really in the post. Now, they did show one where he was fishing, and he did slip and fall right there on the embankment. He has a lake outside of his home. And they also showed him riding the horse the one time he said that he did ride a year later, and saying that he ended up paying for it. That was basically what they showed the entire time. They also showed one of the more important videos was the day after the incident. He didn't preach, but he had a guest preacher. And at the end of the guest preacher's sermon, he kind of hopped onto the stage. So they kept playing it back and forth, back and forth, back and forth, regarding the hop. But my dad kept explaining to them how low to the ground it was. And he ended up paying for it then because it landed him in the hospital, Fayette Piedmont, that evening, not even the next day, late that evening. I talked to you guys about the pretend investigator that they had. They said she was not an expert. And if she was indeed a lay witness, that wasn't going to work. So her testimony was definitely struck. One of the key things here for me was them trying to go around the judge's order, which is prohibiting them from mentioning my relationship to my father. And despite the judge's instructions, he still made it known in his opening statement. So he literally comes behind our chairs and says, "This right here, guys, is the plaintiff. And right here is his daughter." And kind of lost it, but I immediately started writing on a note like, "Hey, this is a mistrial." Told my opposing counsel, "You need to stand up. You need to, let the judge know." We did all of that. The judge took out the jury. He asked the court reporter to play back what he said during motions in limine. And he said, "Yep, it's not coming in. It's not relevant." We then proceeded to ask for the mistrial. The judge said he was not doing that. He was going to give a curative instruction. And that's what he did. But it ended up working in our favor. And that's information we learned after speaking with the jury. Winning checklists. Depositions are key. I will say that question asking has always been a great strength of mine. My parents always called me their watch child from little. I've always been very curious, always asked questions, always wanted to know things, which has definitely played out well for me in this profession. So I do a lot of my work up in my depositions. So when it comes to trial, I'm just impeaching and it makes you just look bad. So that's one of the greatest things I think that you can really do for your case is to do depositions. Admissions for sure, because what we realized as preparing for trial that they never answered our admissions. So all this talk about, sharing a responsibility, there being a percentage of fault on behalf of my father on the verdict form, all of that was squashed because basically they never answered our admissions. And this is a real big thing in the state of Georgia. If you don't answer the admissions, they're deemed admitted. So make sure you write your admissions in a way that if they don't respond, whatever it's admitting is really good for your case. So that was huge. Having the right experts is very important. There are a lot of doctors who do not do trial work, like Dr. Polidor. He's accustomed to this work. So having somebody who's not afraid to take the stand, who will take the stand, and will really help your case. Also, my economist, I found him on the GTLA listserv. He was solid. I don't think that there was really any defense economist that could compare to him, and that the jury picked up on that when they were listening to their economist. Witness prep, all of our witnesses were very key to the case. Just to talk about a few of them, we had two neighbors, two of my parents' neighbors who he has also done work for, but also know him to be a great community man. So that was really good too. And we diversified the witnesses, which was good. So the two neighbors were Caucasian, and then we had two members from the church who have been with him for a very long time and are over the finances. Because one of the things they were trying to say was, well, did he get paid from the church? I think they asked a question like that during depo. He actually gets a stipend from the church, but he does not get paid from the church. They have a very small church of about 25 to 30 people. So it was really good to have them. And then we, of course, had my mom take the stand, which her testimony was powerful. All right. And then, of course, client prep is very important, making sure they have their deposition transcript so that they can remember some of the things they said, especially when there is a large gap between when they did their deposition and when trial actually comes about. Again, I mentioned this earlier, the personal injury trauma therapist has been a game changer. She's amazing. Her name is Yvette Searson. When she took the stand, the judge, you could immediately see he felt her power, the jury felt her power, so much so that at the end, one of the jurors said, if the judge would have allowed her to go forward, and I'll explain why he didn't, I would have advocated for about 4 million for you guys in the back. The reason why he didn't allow her to go forward was because opposing counsel said they were not made aware of her and they kept arguing that she was an expert. We kept saying, Judge, she is not an expert. She actually is a treating specialist. But the judge didn't buy it. Talking about Judge Roth and how he handled the case and the way that that's another story for another day. Still a good judge, fair for the most part, but interesting nonetheless. The trial binder was also very, very, very key. When I had to speak on a panel, maybe about 2 months before trial, I met a young lady whose name was Amber. She was getting ready to graduate from law school, but she had her own business as a paralegal, and she helped to put together trial binders for attorneys, help you get ready for trial. She's done countless trials with attorneys as well. And she came in and saved the day with showing my team how to put together a dynamic trial binder, which was very important, especially with Judge Roth, because he would constantly ask for proof of things whenever there was an argument and he had to call out the jury for any issues. That was the game changer. Choosing the right co-counsel. So, of course, as I mentioned before, Atkins Daughtery and I have been working together for years. I knew that our energy would work well together. I knew that he was about his business. He taught me pretty much almost everything that I know as it concerns trial, prep, all things, depositions, all the things. So it was only right that I had him as co-counsel, and it definitely paid off. And he also knew way more than me because he's tried countless trials, and he's really good at voir dire. I'm really good at question asking. That's the reason why I only put him over kind of the formalities. So if you kind of paid attention, he did all the experts because there are certain things you want to get out. If they're Daubert motions, I wanted to make sure he had all of that. I could handle all the other things. Organization and preparation is, of course, key. Of course, I don't think I have to stress that. There are so many moving parts when it comes to trial that you have to be organized. And then when you have those miniature arguments in between and the judge needs you to pull up something or do something, Judge Roth was not giving us more than 3 minutes to handle anything. So that trial binder was awesome. My paralegal had a table of contents in the front so we could quickly get to things so we could get him what we needed so we didn't lose any of our evidence or many of our arguments. And of course, a good team. My team was phenomenal, phenomenal. You can't do this by yourself. All right, takeaways from the jury. One of the things that kept coming up was maintaining a strong neutral expression throughout the trial to protect your position. Of course, this being my first jury trial, it being my father, of course, the emotions were running high. But at times when there were certain things said, of course, when he disclosed that I was his daughter, when that was against the judge's order, I definitely had a facial expression that many probably won't forget. And throughout trial, there was a statement that he kept, or a question he kept asking. Well, he asked twice, my mother and my father, when they took the stand. And he, being opposing counsel, he said, well, why didn't you go to Restaurant Depot and make them be accountable? What? Like, I just was floored every time he asked. And he asked my mom twice, and she ended up breaking down crying. And that was the wrong thing he could have done, because then she basically started to say, at the time we knew nothing, we didn't know what to do. That's the reason why we hired counsel to handle this. And, throughout these years, you guys have never taken responsibility when you had a chance. But I really think they were trying to get a mistrial on because of something we did, for them to disclose that we attempted mediations. Maybe someone can help me understand why they were doing that, but that's the only thing that I came up with. All right. I told you guys that they really liked the mental health therapist and said if she had testified because they could feel her power and the impact that she made. Of course, her records did still come in, but she could not take the stand. The jury responded very well to our presentation, overall style, and they were fatigued with the Facebook. Like, we could start seeing them shaking their heads because that was literally their only strategy, and they did use that for every single witness. All right. So after the verdict, some of the things that I did, I went on LexisNexis Verdict Analyzer to see where this verdict landed. Surprisingly, over a 37-year span, our verdict ranks fourth overall within this time frame out of 145 cases with plaintiff's verdict. The first one was a $10 million slip and fall verdict against Kroger. That was in 1999. And then there was a $5.5 million verdict against Ross, which was back, I think, in 2012. And then there was another one that was close to ours. I think theirs was like 2.79 against Kroger's 2, and then ours was a 2.65. So we came in at number 4 over a 37-year span. And the average is 445,767. The median plaintiff's verdict is 83,000. So you can find my verdict on LexisNexis on the verdict analyzer.
Go ahead, friend.
Okay, so as I mentioned, it took 4+ years for us to get justice for my father. This is the closing, the money ask. So we asked for, you can see all the numbers here, what we asked for. I want to point out too that we did file a loss of consortium claim separately. We did want to bring it together. The judge wanted us to try to work together to get that a part of the case, but opposing counsel Janice said no, later regretted it. And then we were like, no, you're just going to have to stick with where we are. So we ended up using her loss of consortium claim as leverage, because after we got the verdict, we did go before the judge for the attorney's fees pursuant to 9/11/68, and the judge awarded that. So the final judgment ended up being what you see here, and the money call. So they ended up asking for us to drop the loss of consortium claim. Basically, we were able to use it as leverage. So I always say, always have leverage to some degree. So they said, if you drop it, we'll pay the exact dollar amount. If you drop the loss of consortium claim and don't charge us any prejudgment interest. And we, of course, agreed. So I ended up walking into the same office where we had the mediation and they offered 10,000. That was the same place that I walked into to pick up the check. So that was funny. Definitely did a little video recording, snickering.
Go ahead, friend.
Funny. I know. I was like, Lord, this is a full circle moment. All right. And then, of course, being that I am a PK, a preacher's kid, I am a faith girly. I stand on the word of God. I always tell people I can tell you everything I did from start to finish, but the biggest cheat code, the biggest strategy and instruction and direction that you'll ever get and ever have will be being in the word of God, being a believer, standing on faith. So I always have a scripture that I stand on for every trial. Of course, this being my first one, I am on call for another trial. So we could be called at any point. We are on a 2-hour call, and I have my scripture for that too. But this was my foundation scripture for my first jury trial. That's my mom, my dad, of course, me, my opposing counsel, and my star paralegal, Amber. And I was laughing with Atkins because he was like, you keep saying your first jury trial. Remember when you said second chair? I said I sat in the second chair, but I was not second chair. This was so many years ago, in a dog bite trial. I absolutely did nothing. I was there just watching and learning. So I was like, we were laughing because I was like, I definitely did not sit second chair, but I did sit in the second chair. But this is the full presentation. Definitely excited to share all of this and open to answering any questions, with the disclaimer that this was my first one. I don't know everything, but what I do know, what I did learn, I will freely share.
What an auspicious start to be your first trial. And just congratulations again. And I'm sure we have I have some questions for you, but I just wanted to throw it out to anyone else who had any questions. Don't be shy. That's why Attorney Peterson is here. That's why she came. What questions do you have? Yes, congratulations. That's from the chat.
Thank you. Thank you.
Is Amber gonna help us with our notebooks?
Okay.
Okay, wait a minute. Can she train our paralegal?
I was about to say Amber can start her little business and y'all have to discuss fees.
Yes.
I think she'd be more than happy to do that, but I don't want to speak for her, but I'll talk with her about it.
Okay, so if we
She definitely
needed her, just give you send you an email.
Yeah, send me an email
Okay,
and I'll ask her, because she definitely knows what she's doing, because she just did it for the case that we're waiting to be called for, and she killed it. So she knows what she's doing.
Now, does she work for you?
What does she do? What specifically does she do? Like, how does she organize it?
Oh, wait. My paralegal's name is Amber, but then the other young lady that I met at the event, her name is Amber too. So
yeah, that's what I'm talking about.
That one, yes. Oh, yeah, that's what she does. So I'll give you guys her information. She's graduated from law school. I think in a week or so. So yeah, but I think after that, I'm not sure what her plans are. If she's got a job off. Well, she has to, of course, prepare for the bar. So she probably will have time, guys. If she's
Yeah.
not taking a February bar, maybe.
And yes, that's for you too, Ashley. Ashley asked that in the chat. I had a question. I just came off a very difficult mediation last week with clients with sky high expectations and managing expectations. And I know he was your dad, but what was his feeling when he was offered 100,000 at the second mediation and you all walked away? What was he saying regarding going to trial and gambling that? Like maybe you will get nothing at trial.
Yeah.
How did you manage that?
That's a great question. So the first mediation, he was really, really pissed that I told him and my mom to go ahead and leave. They didn't need to wait for us to all come back together, because they were really disappointed and I wanted them to leave. So they did, and I stayed and talked to opposing counsel. So that was that. But the second one, he was already ready because this was 2 weeks. I don't think I said this. This was 2 weeks before trial, the trial date, the second mediation. So he was already ready to go. He was pretty much in his mind, if I don't even get anything at this point, it's the principal. Now, of course, my co-counsel, being who he is, was saying, now, Bishop, you're going to have to fight me if they offer $1 million and you don't take it. And he was saying, I trust God. I have discernment. We're going all the way. And he was very firm about that.
Okay, very good. And Ashley has a good question. How did him being your father help with the jury?
Oh, it helped because at the end when we were talking to the jurors, I was like, well, what happened? What did you guys think when he disclosed that? Because let me just tell y'all about me. I was so defeated the rest of that day. So it happened on the first day of trial was June 18th. And then we had Juneteenth. So we had a break. And then we came back that Friday. And then Monday was the last day, did closings. And then they deliberated for an hour and a half. I was defeated. It showed on my face. I couldn't even look at the jury anymore. And by the time we came back, I was good. I was pumped up. I was ready. I got myself together. And when we asked them in the back, they were like, they do it all the time. So why can't we represent our people? I think that it was actually phenomenal to see that you were representing your father, a young Black lawyer representing her dad in this case. So that was just two of the people. They were so tired because they had been there forever, so they were ready to go. So we only talked about two or three of them.
Yeah.
That was what they said.
Yeah.
This is Shannon. I was going to ask a question about that because I was fascinated to know the why and how it impacted them because clearly opposing counsel was banking on they already knew that they were told not to say anything, but they were banking on you can't unring the bell. So even if even if he says it, he knows he's not going to, he knows he's not going to get away with it as far as with the judge. However, he was banking really, in my opinion, on the jury saying this is a money grab, right? When it actually had the opposite effect. This is a daughter trying to make money for the family with her father. This has nothing to do with what really happened. And I could imagine what the picture he was trying to paint. And I saw when you gave us a layout of who they were, and I was looking them up, and I'd imagine that they would have been a little more craftier than that, because to me that was a misstep. Never take that position when you don't know what the response is going to be. So I really feel like that was a big misstep, and also how they handled your mother, right? And her cry on cue. And I'm not saying she cried on cue intentionally. I'm just saying,
oh no, yeah,
that you understand what I'm saying? That cry, and then also them banking on something they didn't know really what the outcome was going to be. Clearly, they weren't paying attention to the jury. I just kind of felt like that all played against them. And they're too damn experienced to make those kind of mistakes. That's just my opinion based on what you shared. And yeah, that's my 2 cents on that one.
Thank you, Shannon. I definitely agree with everything you said. I just think that they were not really prepared. I don't think that they thought this would go this far. And I was calling Jay Barber a railroad attorney. They basically bring him in when they don't have anything and they didn't prepare adequately. They bring him in to basically try to railroad the case in any way he possibly can by disclosing things and showing Facebook, using those things. But when that's your only thing, of course, they're going to become desensitized to it. So yeah. And I was really, let me say this though, I was really battling if I should just disclose it and just say in voir dire, would anyone be opposed, or would anybody have bias if an attorney was representing a family member? But then co-counsel was like, no, we'll just get it out, emotions in limine, and if it's out, it's out.
Mhm.
But I battled for so many months. I'd ask my sister, I asked my mom, I asked, people like, what do you think? What do you think? Should I ask this question? How should I ask it? And my sister was the one who said, ask it that way. And I thought that was solid and I wanted to do that. But then opposing counsel, me kind of leaning on him, but then standing my ground on some things, I was just like, okay. But I had a little uneasiness about it. So when it happened, I was just like, because credibility is so key, and I didn't want them to think I lied to them, and I just didn't want to lose that. But I did it. They gave us, if you guys looked at what they gave us everything for the medical specials, which of course they were trying to say, discount him because he paused and went back, but they gave every penny for that. They, of course, shaved him a bit for his lost wages, maybe about 100,000. They still gave the 500 or so. And then you guys saw the 2 million plus for past, present, future pain and suffering. So,
Janae, I have a question.
yes.
Did you ask them, did you ask any other jury, what did they think about that 3-year pause? Because I would have found that, I don't know if I would even have wanted to take that case with the treatment being 3 years later that he restarted treatment. So did that weigh in any, because I don't want to take they ain't been in treatment in 4 months. So
right. But remember he treated the next day for
for 6 to 7 months.
So he was already your client. Got to think, this is already my client.
True.
That's already your client. They're your client already.
That's true. So what the breakdown of the bills was, most of the billing in the first 6 or 7 months?
No, remember it was 21,000. It ended up being 97,000 once we got
70, almost 60,000 of it happened after 3 years.
Yep.
Child, that ain't good number, God. Because really 3 years later, and he had nothing else to happen within those 3 years that would cause them, I guess, besides riding the horse, to be like and falling fishing or whatever.
Yeah, that was it. You recapped well.
See, that's one of the things that the insurance companies will always say. Whether there was a pause in treatment, they overtreated, they undertreated, there's always something wrong with the medical treatment. And so I think there's no perfect case. There's never any perfect case.
There's no perfect case.
All cases have their warts. And I think that is just, be courageous, go ahead and take it. They were absolutely playing in your face, being disrespectful with those offers. Sometimes you got to take that gamble. But my thing is just making sure the client understands we have 100,000 now. If we go to trial, we have 0. I want to make sure you're okay with that and make sure that they trust you and they want to move forward. And then you can have this kind of result.
Now, I think that it is important, though, that you do have something in writing when you do have a client that you can't really decipher how they will show up one day versus the next. So you want to get that in writing. With me and my dad, he was very solid on his position, and he was my father. So, of course, there was some lacks there. But at the same time, remembering that the bills were 97, the offer was 100,000. We weren't losing really anything here.
Right.
If you have 100,000 in bills and you have $1 million off on the table, we need to talk, but we weren't losing anything, honestly speaking.
Yeah.
We had one question in the chat. We had another question from Ashley. Do you think the Facebook strategy took priority because he was brought in at the last minute, i.e. he wasn't prepared, didn't have time to prepare, right?
He said that to the judge because the judge kept wanting us to settle. I'm just like, Judge, this is not going to settle. And he was like, because I would just do it. He was like, I don't think you guys are prepared. I forget what he said. And he was like, Judge, you're right. We're not.
Wow.
So they weren't prepared.
So why should you settle if you're not prepared?
Right.
Exactly. And you didn't offer anything throughout. Like, I thought maybe after day 1 or 2, there was talks about like, who do we email if we want to send an offer, but the offer never came. Because mind you, we had the whole weekend and then we came back Monday for closing and then deliberations. So
I think that is so interesting. Okay, so I'm interested in the demographics of the jurors who stayed and talked to you. Were they white men, the black men? Who?
It was a black man. It was a black man, and then the alternate. Okay. She did the most talking to us.
Okay.
And the black man, he worked for Grady in the retention department. So when it came down to them not saving the video and certain records and things like that, because the 30B6 deponent, there was an affidavit that in one of their last motions that they filed, a lot is filed right before you go to trial. There was a motion that they filed, and there was an affidavit of the 30B6 deponent. And his affidavit basically said that it would be too much. I forget all the words he used, but it would be too much for them to go through their records to find something we had requested in discovery. And I used that basically to show, like, basically, you just said in this that you didn't care, that it would have been too much for you to get what we asked for, basically, is what you're saying. Well, no. And you said previously that you worked for Sam's and they have one of the greatest retention programs, and you didn't choose to bring that program here to Restaurant Depot. They were looking like, yeah, no, sir. He was like, I work in retention, and when you don't do that, you'll be fined to high heavens. And that was it for me. So you just got to know your people on your jury, what different things will tick them off based on the information you have, and bring that out.
Absolutely. We have a question from Attorney Royce. Can you share which insurance company the defendant was insured with?
Liberty Mutual. And that's a good question too, because some people, I thought I was gonna get asked this question. How much did they have in insurance? It was 4 million.
$4 million policy. Okay.
Yeah, because sometimes you get a verdict and you end up taking 150,000 because that's all they have. But here we were able to get every dollar because it was up to 4 million. It was a $4 million policy.
Okay.
Do you mind, this is Shannon again, do you mind sharing your strategy on and you all's approach for your OOJ? Because I know that there are so many talented attorneys in this chat and in this session here today, but that is such a critical part too, especially since they initially had such a low offer. And then when you guys drafted your OOJ, even with theirs was still, in my opinion, low. So what was you all's strategy behind that?
So if I would have showed a picture, it also had my mom's loss of consortium claim in there. So it was for the both of them. So we basically said, hey, we feel like the bills are 97,000. We have the economist. He's solid. They'd already deposed him. He didn't crack. We had basically saw that everything we had was going to work in our favor in our opinion. And we saw that they didn't have anything because this has been 4 years. I know what they have versus what they don't have. We had the admissions. We had a lot working for us. So we chose to ask for the million because we felt like if that's 500 for my dad, 500 for my mom, that would be sufficient, or a little bit more really for my father than my mother. But we didn't care how they were going to split it. We just basically threw it out there. But yeah, because I think the last offer when we were talking, I was talking with co-counsel and my dad. My dad wanted tremendously more too. So of course, you have to listen to your client because you essentially work for them. So you have to, of course, it's very important that your client is in agreement with whatever it is you ask for, because that OOJ, when you put it out there, you have to stand on it. If they give you that check, you've asked for that. It's no going back. So yeah. So talking with my dad, he was like, at minimum, 1 million. So that's what we did.
All right. I think there was like one more question. Can you please share the name of the trauma therapist and why she was crucial?
Yes, Yvette Searson with Personal Injury Trauma Therapy. So they're a fairly new company. So the husband and wife that started this, the wife was a chiropractor, and she said when people would come to her practice, they would always talk about the mental trauma that they're experiencing as she was, manipulating their back and doing adjustments and things like that. And she had this brilliant thought. And I think her husband, because I did work with them a couple of times in the past, her husband worked in the business with her. So they connected with a lady who was Yvette Searson. They go way back. They knew that she was a trauma specialist. She's not a therapist, but there's a therapist that's over her. But there are courses that you can take. There's certifications that you can get to be able to do this work. And she's a game changer, and it was crucial because all the things that she talked about are things that you don't normally hear about that get left behind. You have the doctors who treat them for their physical injuries, and then of course you have the attorney who advocates for them for the money part, but the mental trauma is not dealt with really. So having someone who specializes in this and can speak to this is very important, because a lot of times they are really depressed and they're going through, and she's helping them to cope and get over it by way of her strategies and disciplines that she's learned along the way. And might I add, my clients have used her and they rant and rave about her. Like I had one client, she's elderly. She was literally losing her scruples when she missed her appointment with her. And I've had about, at this point, 6 or 7 people treat with her, and they've all talked about how much of a game changer she is and how they're able to move far beyond of what they could, what they thought they could now having her. Because we don't start them with her right away. We kind of try to assess and see, and then we ask, hey, if you still feel this way in about 2-3 weeks, then we'll introduce you to Miss Yvette. And that's typically when we give that information.
Is that Dr. Mindy?
Yes, it is.
Oh, okay, I met her. We used them for years, her and her husband Terrence.
Yep, that's exactly
Yeah.
who it is.
Oh,
Yep.
okay.
Does she treat on a lane?
Yeah,
She
they do.
does.
Because
Yeah.
this is what they got into it for, because they knew that there was no one doing it.
We just met with them to do to think about adding that to our business.
I would say do it right away, immediately. A game changer for sure.
Janae, I was gonna ask you, when you win the case, I saw you said attorney fees, you get the attorney fees and you get the percentage that you like the third percentage or whatever. How does that work?
So it all goes together. So once we go back to court and we get the fees for the 9/11/68, we add it all to the pot and we take our fee off of that.
So the 9/11/68, is that the bad faith?
No, 9/11/68 is the OOJ.
Oh, the OOJ,
The
that's
offer of
the offer of
settlement.
settlement.
Yeah.
Okay.
Yeah.
So okay, can you walk through how that works? So
Yeah.
I know that a percentage of it I know it's something like if you don't get
25%, you have to get like 25% more than what you asked for of the million. And once you get that, then you basically have cleared the way for you to be able to get the attorney's fees.
And interest. Right?
And interest, that's correct. And
so
interest.
you would get money off of that plus the regular attorney fees.
No.
I'm
So
sorry.
basically, so you get, so whatever the additional, so let me go back. Let me see, can I go to the slide?
Okay.
All right, so do you see where it says jury verdict? You have the jury verdict amount here.
Yes.
And then you have the attorney's fees, 9/11/68. So we
Yes.
asked for, if you look to the left, what we asked for was attorney fees and expenses of $75,251.67.
Gotcha.
But what the judge allowed for us to get was the $56,940 plus the expenses there. And so we added that to the 2.658. So you're entitled to your attorney's fees and expenses if you get over the 25% of what you asked for. Okay.
That makes sense. Yes, that makes sense. So why wouldn't this be considered a bad faith claim if you had the specials and they didn't settle any amount? They settled an amount that was so close to what his specials were.
Yep. But bad faith claim, and of course, Terry can correct me if I'm wrong, but a bad faith claim is typically when you've asked for policy limits and you don't get policy limits.
Correct.
Gotcha.
So we didn't ask for policy limits. It was a $4 million policy limit. And at the time, we only had 21,000 in bills. So we only asked for, let me go back to that slide real quick, because
76 something. You guys were precise.
Yeah. And 20 cents.
Right,
Yes.
that's 20 cents. And I think when I
Yes.
looked up, there it is right here. So yeah, there you go. Because it was 23,623.20.
Okay, so that'd be more so if you had a $25,000 policy, maybe, and the specials may have been 30,000.
Say it one more time.
If you had a $25,000 policy and the specials may have been 30,000,
There
then
we
that's
go.
a bad faith.
And I asked for 25 there. Yep, that's correct. Or if it was 100,000 and we asked for 100,000, whatever it was.
All right, I got that. Okay.
But
Thank you for those distinctions.
Yeah.
No problem.
But I just want to throw out there to y'all the 9/15/14, which I love. I love a 9/15/14 litigation in bad faith. This case should have been settled. You have the offer of judgment, the 9/11/68 as well. But then a 9/15/14, I will put that in there any time, any place. I put it
But
in
you can
all
get
my
that
motions.
plus, you can get that plus that. You can get both.
Now that would depend on the judge, I guess, and the
Right,
case. But
yeah.
I will throw it in. If I feel like it's frivolous litigation, we should have settled this. You playing 9/15/14.
Yeah,
That's
I'm
my
using
favorite.
that in the case that I'm waiting to be called for.
What's 9/15/14, Terry?
Frivolous litigation pursuant to a tort. Now, if it's pursuant to a contract, it's a different statute. It's like 11. I can't remember what that was. I'll put it in the group me. I'll put it in the chat. But always. All right. So let me just do this. There's another question in the chat. I think it's regarding to your expert. Was it judge's error not to allow her to testify?
I would say yes. But at the same time, when they said what they said, I don't know that I really had all of what I expressed to you guys ready to say at the time. I think I just kept saying, Judge, she's a treating specialist and her records are in evidence. And the judge didn't buy it because they were saying she was an expert. But if I could have said, Judge, although she's not necessarily, and that's another thing too, and I'm gonna be completely transparent with you guys. I want her to actually get her license as a therapist, because I think that there can be an issue if they really question her down to the T, right? And I've even talked to them about having the therapist to do the first initial view or review of the person and then recommend them to go to the specialist, because I don't know that she would be deemed an expert. Of course, I haven't done a lot of work on what makes one an expert, because she would have to pass Daubert. And whether or not she would, I don't know. Again, they're a new business, so I do want to put that out there. She didn't get questioned all the way to the T, and I was their first trial. So I will put that out there.
Okay, let me see. Do I see any other questions? Okay, so Ashley asks, did you all get a client's future life care plan? Because you did have an economist as an expert. She said she's seen where companies are offering that at the onset. Do you think that's beneficial or necessary in all cases?
I don't think it's beneficial or necessary in all. Well, I would say I don't think it's necessary for all cases. It may be beneficial, every time, but maybe not. I don't know what the numbers might show or prove. But I have seen it that they go hand in hand, but in our case, we didn't have it and they didn't argue anything about it. But again, I don't think that they were lawyers that were really prepped and ready and did their job and work. So I wouldn't hang my hat on that every time, because what I have heard is that the two do go together. Now, for him, again, there were no loss of limbs, there were no hospitalizations or surgeries or really permanent injuries to where I feel like that would have been of great use to spend that amount of money for it. But I do think if the facts are there and the injuries are there, the answer would be yes.
Yeah.
And they do have, those companies have different tiers. You can get a summary, and I wish I could look it up and send it and drop it in our group chat, but
you can data, Shannon.
I think so, because there are different tiers of it, right? So you can get like a summary, you guys, that'll give you an idea of what those costs could be. And I want you to know that it's probably somewhere around $1,500 for those cases where you know that you don't really need to spend that substantial amount of money to get the details that go behind a life care plan. Or you can, obviously, if you have a larger case where there are maybe loss of limbs or they've already been declared like they absolutely cannot work for the rest of their life and what their value was prior to that injury and all of that, you definitely want to go into those details. But there are different tiers that you can use to your advantage if you want to introduce something, especially when you have a client who is clearly injured. They don't want to go to get the surgery. They maybe even have an estimate for the surgery, but even if the narratives in their medical records dictate, hey, this is what they're going to face, then I would say then you might want to use one of those tiers that you're not spending a substantial amount of money on.
Definitely agree. And MD Data, sounds like you're talking about MD Data. I just became aware of them probably a month ago, and they're like 1,700. And they came into fill a gap that wasn't being filled, which is for cases of smaller nature, where it's not like near death or death. They will do a life care plan for you, which I think is perfect, because typically when you think of life care, you do think about those loss of limbs, you have to have surgery or you're going to be paralyzed for the rest of your life. But they've come in and they say, if you need future treatment, things of that nature, they could put together a life care plan. Also, as you were talking, Shannon, I just thought about why I also went against it, because Dr. Polydor, he basically filled that gap too for us. So he was the one who said, he needs to do these many injections, and then if it doesn't work, I will recommend him for a fusion.
And he's phenomenal. By the time he get on there, it's game over. He's phenomenal.
Okay, exactly. And I have, and he's a pretty penny. So
when you were thinking about trying to figure out the name, did he go to Revive? Because I know that he had moved around a couple times. Dr. Polidor, I didn't know if he went with Revive Orthopedic when you were trying to figure out who he was with before he went out.
That sounds right. I can't place it either.
What did you say, Shannon?
Revive.
No, that's his company now. But before he was with, it wasn't Barbara. I can't remember, but yeah.
No, but it was a big one. I remember it was a huge network.
It's over here by me. By the airport, I can't think of it, but yeah, he was with them for a long time.
Well, and that brings me to a point I would like to make about this community that we have created and fostered and that we want to keep going, the Lady Lawyer Mastermind. If you have a case and you have questions like that, maybe you just want to do like a little powwow, a little group session, short or long, and you just want to get together with those of us who litigate personal injury cases, and you want to ask a couple questions and pick our brains. We are open and amenable. I would love to hear what's going on with other people and how you're doing your cases, what questions come up. And we are here to help each other. Just like Janae was saying about the attorney they do it. They help each other. They represent their family members, their loved ones, their people in their community. They stand on each other's shoulders. We can do it too. And that's what this is all about.
That's right, Terry.
That's right. We're celebrating our sister's win. And she's here to help us so we can do the same. And we want her to continue to go out there and slay dragons and do the same. Number 4, verdicts in 37 years in the state of Georgia is nothing to sneeze at. You should be so proud. I'm proud. It's like I do. I'm so proud.
Especially her first trial too.
Yes,
Come on now. That is auspicious.
You need to make some TikTok saying that.
I need to sit with you. That's what I need to do, and you tell me what I need to do, because that's not my thing.
I've seen some stuff.
Yep. Yes. Whatever you need, we have it here in this community. So we just are so proud, and that's why we wanted to do this. And we want to know this help is available to you. If you need any help, you just want us to get together and just talk about your case. Let me see if there's any other questions. I know we are all busy. It's the Christmas season as well.
Hey, these folks want their checks. They want their monies.
And it was Polydor. I'm sorry, I can't see who asked the question, but what was the name of the doctor you were just speaking about with Reviving is Polydor. That's who we were talking about.
Shevin.
And Janae, was your dad treating while you guys were litigating? Because you said it was a 3-year gap.
He was.
Okay.
He actually was. He had another, I think, appointment the week before trial. His last appointment. Because he still had things they called after we won. It was like, is he still gonna be? Y'all know the answer was
no, he good.
He gonna go as needed. He's gonna go as needed.
Well, congratulations again. That's all I
Congratulations.
Congrats. You know, we are so proud of you.
Thank you so much for coming on.
All the kudos.
I appreciate the support. And I'm here for you guys.
Yeah, so anybody, if you're not in the Lady Lawyer Mastermind group me, please feel free to reach out to me with any questions. I'll get you all the information. The others of us will go ahead and post all the information in the group me. And I posted the Georgia code where you can get attorney's fees for frivolous litigation pursuant to a contract. It's 13,611, but for torts, it's 91514. So anyway, but I don't want to keep you all. I don't know. I'm hungry. I don't know. It's lunchtime. I don't know if anybody else.
Thanks, guys. This was great.
Time to get that lunch. Well, and we will do it again next time. Please be on the lookout for webinars. And then we have our, let me just share this, our little website for the Lady Lawyer Mastermind. We have another one that's coming up in April. We have decided to do these yearly. We had one scheduled for this past October, but we had to cancel it, unfortunately. I thought I had this up. There it is. The Lady Lawyer Mastermind. I encourage you, if you're not already, if you haven't already attended, please come and plan to attend the next one in April 2026. We'll get all the information about the speaker. In the past, we've had Ianla Van Zant, and we've had C.K. Hoffler and Marita Johnson. They have come to speak to us, and we're going to continue that legacy with wonderful speakers. We have Judge Penny on deck to come speak to us at some point. So we look forward to having you all. So reach out to me with any questions. Otherwise, please come on the group me and we'll post all the information.
Thanks, guys.
Go out there and kill it, ladies.
Thank you.
Y'all have a wonderful day.